Well, good evening, good evening, good evening. This is the Minister M.L. Kimble coming to you live and wanting to go ahead and cover with you guys the pending Exhibit Q that is going to be filed in the federal complaint, Kimble versus Swanton Police Department. You guys understand that we've already released the documented evidence of the conversations between the mayor and the suspect that was responsible for the burglarization of our business the second time, which was documented, and also court documents identifying her as the person responsible. Yet these conversations document, unethical conversations between leadership, which would be government actors, and private parties, which support the allegations in our federal complaint. So please like, share, comment. Don't forget to subscribe. Please understand that this is not legal advice of any kind. I am not an attorney. FCN Watchdog Media Global is not attorneys. We cannot give you any type of legal advice. So just understand that this is just an educational purpose for while I'm going over this, and this is not in any shape, form, or fashion legal advice. Again, I am not an attorney, and I cannot give you any type of legal advice. If you do ask me that information, I'm going to tell you to go search for an attorney. I decided that I'm going to deal with my situations pro se, and I've been able to do so, but I've done a lot of studying, and it takes work. You cannot just expect to go and defend yourself in any situation and you don't do any studying to show yourself approved. So with that being said, we're going to go ahead and go over this pending exhibit that will be filed at the moment that Judge Helmick does bang his gavel. I want you to understand something. It doesn't matter whether he okays the amended complaint or he does not okay the amended complaint. This exhibit will be made public because it supports both the amended complaint and the original complaint, which is the suspicion of the involvement of the current sitting mayor, Mr. Neil Toeppe, being involved in this whole situation, which caused our business to be destroyed. And we're going to hold these people accountable. I don't care how many years it takes. I don't give a damn. These guys will be held accountable, and any piece of information that we have, we're going to release it to the public. United States District Court, Northern District of Ohio, Western Division, Minister Marquise L. Kimble versus Swanton Police Department, ETAL. Case number 325 is CV01810JJH. That stands for Judge Jeffrey J. Helmick, Magistrate Judge Darrell A. Clay. Exhibit Q. Supplemental analysis of documented email communications between defendant Mayor Neil Toeppe and Deborah McSurley concerning 108 South Main Street, Swanton, Ohio, in support of the First Amendment amended complaint. This Exhibit Q is submitted as documentary and analytical support for the First Amendment complaint and is intended to be read together with paragraphs 1 through 41 of that pleading, with particularly relevance to paragraphs 2 through 4, 11, 17 through 18, and 19 through 26, 32, 34, 38, 40, and 41. The First Amendment complaint alleges that this action arises from an alleged pattern of constitutional violations, discriminatory treatment, coercion, obstruction, interference with property interest, denial of access to the courts, and coordinated acts by police actors, municipal officers, officials, insurers, attorneys, and other actors following a hate crime attack against plaintiff black-owned business formerly headquartered at 106-108 South Main Street, Swanton, Ohio. The attached email image reflects a direct written exchange dated April 8th, 2022 concerning 108 South Main between defendant Mayor Neil Toeppe and Deborah McSurley. The mayor's message asks about the status of your tenant, refers to prior discussions concerning whether the tenant would become current or whether the property would be placed up for sale, states that there had been some inquiries from individuals looking for space, and asks whether he should refer those inquiries to Deborah. Deborah's response states that there had been no word from Marquise, that we have changed the locks, that we are replacing the door that was destroyed, that they were in the process of cleaning out the building, and that they were looking at selling the building and wanted it listed or occupied in May, if at all possible. Direct cross-reference to the First Amendment complaint. This Exhibit Q directly corroborates the following pleaded allegations from the First Amendment complaint. Paragraphs 2 through 4. The action arises from an alleged pattern of constitutional violations, discriminatory treatment, obstruction, interference with property interests, and continuing deprivation of civil rights following the attack on plaintiff's Black-owned business. Paragraph 11. Mayor Neil Toeppe is alleged to have been the chief executive officer of the Village of Swanton and to have exercised supervisory authority over the Swanton Police Department. Paragraph 17 through 18. Supporting exhibits are incorporated as documentary and analytical support for the factual allegations, claims for relief, and rebuttals to anticipated defenses. Paragraphs 19 through 23. Plaintiff alleges a hate crime attack, delayed and deficient police response, failure to investigate hate crime indicators, suspect-style treatment of the victim, and resulting harm to plaintiff's ability to protect property, preserve evidence, obtain justice, and secure fair treatment. Paragraph 26. Plaintiff alleges that coordinated acts by police actors, municipal officials, insurers, attorneys, and other actors combined to deprive him of property, liberty, equal protection, due process, access to the courts, contractual rights, and civil rights protections. Paragraph 32. Plaintiff alleges that as an African-American business owner and hate crime victim, he was treated differently and adversely on the basis of his race. Paragraphs 34. Plaintiff alleges municipal and supervisory liability under Monell and related standards based on customs, policies, deliberate indifference, failures in training and oversight, and ratification of unconstitutional conduct. Paragraph 38. Plaintiff alleges conspiracy and failure to prevent conspiracy under 42 U.S.C. 1985 and 1986. Paragraph 40. Plaintiff alleges retaliatory conduct and interference with speech, petitioning activity, media activity, religious exercise, and access to the courts. Paragraph 41. Plaintiff asserts additional due process, obstruction-related, fraud-related, and injunctive relief claims as set forth in the incorporated pleading and supporting exhibit materials. Why the email chain matters. This email chain is not offered as an isolated communication divorced from context. It is offered because it places defendant Mayor Neil Toeppe in direct communication with Deborah McSurley regarding post-loss control, exclusion, cleanup, repair, marketing, occupancy, and prospective sale of the very property identified in the First Amendment complaint. While plaintiff alleges that he was the victim of a hate crime attack and was therefore denied equal treatment, meaningful protection, and fair process. The significance of the communication lies in what it shows the mayor knew and did. The mayor knew the property was in transition, knew the tenant relationship was at issue, knew that the door had been destroyed, knew that the locks had been changed, knew that the building was being cleaned out, knew that the sale or reoccupancy was being contemplated, and affirmatively offered to channel additional prospects to Deborah. That sequence is materially relevant to the First Amendment complaint because it supports the allegation that municipal leadership was not detached from the consequences of the underlying incident, but instead was aware of and participated in steps affecting the possession, control, and future disposition of plaintiff's former business premises. Relevance to municipal and supervisory liability. Paragraph 11 of the First Amendment complaint alleges that Mayor Neil Toeppe was the chief executive officer of the Village of Swanton and exercised supervisory authority over the Swanton Police Department. Paragraph 34 alleges municipal and supervisory liability under Monell and related standards for customs, policies, deliberate indifference, failures in training and oversight, and ratification of unconstitutional conduct. This exhibit supports those allegations because the mayor is not depicted here as a remote official passively receiving background information. Instead, he is shown initiating a property status inquiry, acknowledging prior discussions about whether plaintiff would remain current or whether the property would be sold, identifying outside demand for the premises, and offering to refer prospective occupants or users to Deborah. That conduct is relevant to a Monell and supervisory liability analysis because it tends to show policymaker awareness of, participation in, or ratification of actions affecting plaintiff's business location after the underlying hate crime related loss and during the broader course of conduct challenged in the First Amendment complaint. Relevance to due process and property interference. Paragraphs 23 and 26 allege that the deficient investigation and coordinated acts of municipal and non-municipal actors materially harm plaintiff's ability to protect property, preserve evidence, obtain justice, and retain civil rights protections. This exhibit supports those allegations because the communications concern matters central to the property control and inclusion, lock changes, replacement of a destroyed door, cleaning out of the premises, listing or occupying the property, and referral of interested persons for future use. Those are not incidental details. They are concrete actions affecting access, control, possession, and commercial disposition of the premises. When read in conjunction with the First Amendment complaint, the email chain tends to support plaintiff's allegation that the actions affecting his property interests were moving forward, while his rights as the victim of the underlying incident were allegedly not being protected through equal, neutral, and constitutionally adequate processes. Relevance to equal protection and race-based unequal treatment. Paragraph 32 alleges that plaintiff, as an African-American business owner and hate crime victim, was treated differently and adversely on the basis of race. Paragraphs 19 through 23 allege a hate crime attack, deficient investigation, and suspect-style treatment of the victim rather than the perpetrators. This exhibit supports those allegations by highlighting an asymmetry in posture. According to the complaint, plaintiff was subjected to delayed, deficient, and accusatory treatment after a hate crime attack. By contrast, the email chain reflects cooperative, facilitative, and solution-oriented communication between the mayor and Deborah concerning the cleanup, control, and future occupancy or sale of the property. That contrast supports plaintiff's equal protection theory because it tends to show that municipal attention and practical assistance were directed towards restoring the marketability and transition of the premises rather than toward vindicating the rights and restoring the position of the Black business owner who alleges he was the victim of the underlying attack. Relevance to conspiracy and failure to protect. Paragraph 38 alleges conspiracy and failure to prevent conspiracy under 42 U.S.C. 1985 and 1986. This exhibit supports those claims because it documents direct communication between a municipal policymaker and Deborah McSurley about a property central to the dispute. And because the communications involved practical coordination about who controlled the premises, what remedial steps had been taken, whether the property would be sold, and whether prospective users should be routed to Deborah. The exhibit does not by itself adjudicate ultimate liability. It does, however, provide documentary support for plaintiff's allegation that municipal officers and non-municipal actors were not operating in isolation, but were acting and engaging in contemporaneous, substantive communications bearing on the very interests plaintiff alleges were being deprived. Count by count support. Count 1, 42 U.S.C. 1983 Fourth Amendment. The complaint alleges unlawful seizure, collection, and retention of DNA, fingerprints, and biometric information without lawful basis. This exhibit supports count 1 contextually by reinforcing the pleaded narrative that plaintiff was treated as a suspect rather than a protected victim, and that municipal actors were engaged in conduct adverse to plaintiff's rights and interests during the same overall course of events. Count 2, 42 U.S.C. 1983 Fifth and 14th Amendments. The complaint alleges deprivation of due process and use of accusatory methods against victims rather than suspects. This exhibit supports count 2 by documenting municipal awareness of and engagement with actions affecting inclusion from and disposition of the premises, including change locks, replacement of the destroyed door, cleanup, and efforts towards sale or new occupancy. Count 3, 42 U.S.C. 1983 Equal Protection. The complaint alleges that plaintiff was treated differently and adversely on the basis of race. This exhibit supports count 3 because it reflects a cooperative posture toward the property side actor, while the complaint alleges that the plaintiff, the Black business owner and hate crime victim, received deficient and adverse treatment. Count 4, 42 U.S.C. 1983 Municipal and Supervisory Liability. The complaint alleges Monell liability, deliberate indifference, failures of training and oversight in ratification of unconstitutional conduct. This exhibit supports count 4 because it ties the mayor personally to communications about the condition, control, marketability, and future use of the property, thereby supporting plaintiff's contention that municipal leadership was aware of and involved in actions affecting his rights and interests. Race discrimination in contracting. The complaint alleges impairment of equal business and contractual rights on account of race. This exhibit supports the factual foundation of this count because it shows municipal involvement in communications about future commercial use and disposition of the former business premises, while plaintiff alleges discriminatory treatment affecting business interests. Conspiracy and failure to prevent. The complaint alleges coordinated deprivation of equal protection, access to justice, property, and civil rights protections, together with failure to prevent the conspiracy despite knowledge and ability to act. This exhibit supports this count by documenting direct contemporaneous communications between Mayor Toeppe and Deborah McSurley about the premises, and by showing the mayor's knowledge of and involvement in matters central to control and future disposition of the property. First Amendment retaliation, access to court. The complaint alleges threats, coercive communications, retaliatory legal conduct, and intimidation designed to chill speech, petitioning activity, media activity, religious exercise in pursuit of legal remedies. Although this exhibit does not contain retaliatory threats, it supports the broader pattern alleged in this count by showing that municipal leadership was actively engaged in property side communications during the broader dispute, in which plaintiff alleged obstruction and retaliation for asserting rights and pursuing remedies. Additional claims. The complaint asserts additional due process obstruction-related, fraud-related, and injunctive relief theories incorporated through the pleading and supporting exhibits. This exhibit supports those claims as corroborative, patterned evidence of municipal knowledge, coordination, and practical involvement in matters affecting plaintiff's property rights and civil rights interests. Specific misconduct by Mayor Neil Toeppe highlighted by this exhibit. This exhibit Q highlights the following alleged misconduct by defendant Mayor Neil Toeppe when read together with the First Amendment complaint. Initiating direct communications with Deborah McSurley concerning 108 South Main Street during the aftermath of the incident central to this action. Framing the issue around the status of plaintiff as tenant and whether the property would be sold, thereby showing awareness of the threatened displacement of plaintiff's business interests. Advising that he had received inquiries from persons looking for space and offering to refer those persons to Deborah, thereby facilitating prospective transfer, occupancy, or commercial repositioning of the premises. Receiving and accepting information that locks had been changed, the destroyed door was being replaced, the building was being cleaned out, and the property was being prepared for listing or occupancy without any indication in the communication that plaintiff's rights as the alleged hate crime victim were being protected or prioritized. Providing evidentiary support for plaintiff's allegation that municipal leadership had knowledge of and involvement in actions affecting the premises, while plaintiff alleges that he was denied equal protection, due process, and meaningful access to justice. Conclusion. Exhibit Q is offered as direct documentary support for the proposition that defendant Mayor Neil Toeppe was personally involved in communications concerning the condition, control, cleanup referral, occupancy, and prospective sale of 108 South Main Street after the attack on plaintiff's Black-owned business. When read together with the First Amendment complaint, the exhibit strengthens the pleading allegations of coordinated action, municipal and supervisory involvement, interference with property interests, unequal treatment, deliberate indifference, conspiracy, and failure to protect civil rights. Mr. Mayor, you can't run from your scam. Be a man and accept that your scam is now public.